Clemson and Florida State still in court against the ACC on four different fronts. And of course, Clemson has sent out a bit of a smoke signal in recent days to say things could be announced very soon. We got Tony Siracusa on the line. Last word on college football. Tony's been following the proceedings rather closely. Tony, we put out our own bat signal for you again.
Sure, no problem. And yes, I've been following them closely to the point of being on these really uncomfortable old wooden benches in the Mecklenburg County courthouse. And it's not much better in Tallahassee and Leon County. And we're about to find out what it's going to be like in Pickens County as we head down to South Carolina to follow the hearings on Clemson versus the ACC, because as you pointed out, we've got different lawsuits on different fronts. We've got the ACC as the petitioner or the plaintiff in Mecklenburg County against Clemson and against Florida State. Then we've got Florida State as the petitioner in Leon County. And now we've got Clemson as the petitioner in Pickens County, South Carolina. So, yeah, we've been following it closely. Like I said, you'd think these courtrooms would have better seating, but, it is what it is.
Hey, theater seating has come to the cinemas a long, long time ago. So,
right? You would think it wouldn't take that much to renovate a simple courtroom.
Well, I'm going to let you know, Tony, what stood out to me in reviewing the last few days. And then, of course, you can tell us what's important.
Sure.
Judge Lewis Bledsoe, within a 53-page document, stated that North Carolina would be the proper place to enforce both, enforce and interpret these cases. And so the first thing that comes to mind for me is because the ACC is dealing with a contract that is exactly the same contract with two entities, Florida State and Clemson, and treats them exactly the same, supposedly, that this becomes one consolidated case.
You hit on a really great point, Mark, and that is that last week when Clemson had its hearing in Charlotte on its motion to dismiss the lawsuit brought by the ACC, Judge Bledsoe has dismissed that. And during the hearing, he brought up a not so rhetorical question about why should we have hearings that are essentially based on the same issues, the same contracts, the same grant of rights? Why should we have them in different jurisdictions, which makes them subject to various state laws when it should all be interpreted as one, or could be interpreted as one? Obviously, the ACC agrees with that. And the ACC's position all along has been, we are located in Charlotte, therefore all of these cases belong in Charlotte, in Mecklenburg County. Look, this could have been these jurisdiction issues, these venue issues could have been decided long ago if the attorneys who put together the bylaws for the ACC and who put together the grant of rights had not been so horrendously sloppy. They should have had a choice of law clause in there, which would have mandated where any litigation goes before you even sign the contract. If I want to sue my credit card company, I have to go to Delaware because the agreement I signed with the credit card company says so. That's called a choice of law clause. It's very common in business contracts, and it is nowhere to be found in the grant of rights or the ACC Constitution. And it's really sloppy that it isn't. But to your point, yeah, Judge Bledsoe was asking the question, why can't this be heard in one venue? That having been asked and not really answered to this point, we have Florida State, who was denied their motion to dismiss in Charlotte. They are appealing to the state Supreme Court in North Carolina. This is a special court in Charlotte. And when I say special court, it's referred to as a complex contract business court. It is different than the other civil courts where this person sues that person, this company sues that company. This is a particularly complex situation because it involves multiple states, It sovereign immunity, if you believe Florida State's argument, and personal jurisdiction, if you believe Clemson's arguments. So it's in this special business court. And so you get to skip the rest of the appellate process if you're going to appeal a decision out of here and go straight to the state Supreme Court. Now, having said that, and having had a look at the state Supreme Court upcoming dockets, there's no chance that that case gets heard before early spring 2025. So we're kind of, and then what Florida State did was they went in and said, since we're appealing, you have to stop the rest of the case. No more discovery, no more trading of information or any communication. This has to just stop until it's decided if this is going to be the venue or not. And Judge Bledsoe really had no choice but to agree with that. What's next is we will see if Clemson makes the same appeal. I venture to guess they probably will, and they'll go straight to the North Carolina Supreme Court and appeal the judge's ruling. A little bit of difference with the ruling in the Clemson matter is the judge did dismiss a couple of the claims by the ACC against Clemson. One in particular was that Clemson was violating its fiduciary responsibility to the ACC, to the conference offices, to the other members by breaching its contract. It hasn't actually breached its contract yet. It is filing in South Carolina to get out of the contract, but it doesn't really constitute a breach of contract at this point. And so the judge did dismiss a couple of the, I guess I would call them smaller claims by the ACC, who was looking for some financial recompense from Clemson for these violations, and the judge kicked those out of the case.
Tony Siracusa, last word on college football. Clemson, Florida State, a key series of events here recently, and both going forward in the near future in their cases against the ACC and the cases of the ACC against Florida State and Clemson. So the next thing that stood out in reviewing the last week or so for me was that there was a scheduling disagreement between Clemson and the ACC regarding, well, one was a South Carolina football game that the ACC wanted to move to Black Friday. One involved Clemson wanting to play NC State at home on a opening weekend. And what surprised me with all the college football that I've covered through the years, because I'm guessing that those differences are taken care of course, before it becomes public, but that Clemson just outright refused.
Right.
While the comparison was made to the Florida State, Florida schedule going back to 2022 and their game being moved to Black Friday. And one of the notations in the University of Florida press releases had to do with stating that, this is an SEC rights under, their jurisdiction versus, in contrast, the ACC owning the media rights, which is a key clause, if accurate, the ACC media rights owning that Clemson dynamic.
Yeah, you hit on an interesting point that kind of brings us to a broader picture of something that we learned in the filings in the Mecklenburg County case. And that is that there were conversations and negotiations going on in January and into February between Clemson, between the ACC, and with ESPN as part of it. And the broad picture of it was there were contract conversations going on. There were, I don't know if I would really call them negotiations, but there were conversations to see if there was a point where we were actually going to be able to avoid litigation in this case. It was a broad brush table of conversations on different topics. You pointed out the TV issue. They wanted to move the ESPN and the ACC wanted to move the Clemson, South Carolina game to Black Friday. And in exchange for doing that, ESPN had agreed to put the game on in prime time. It's currently scheduled for 12 noon local time on that Saturday instead. there were other things that ESPN and the ACC were going to be willing to give up. They were going to move an upcoming North Carolina State Clemson game to a Clemson home game and front load that and make the away game, make the North Carolina State home game later on down the schedule within the next, I think, 3 years. They were offering a lot of accommodations to Clemson, and it's not really clear that they were offering these accommodations in exchange for not suing, but in terms of a good faith conversation. So you can't really paint it as a quid pro quo, but we're having these conversations. Then what we learned is all of a sudden the communication stopped. In late February, first week of March, Clemson stopped returning messages, stopped returning emails. None of these conversations, it's important to note, none of them were face-to-face. They were all over text messages and emails, but they were there. The stopping of the communication from the Clemson end coincides with them getting a new lead counsel for this case. And as Clemson pointed out, they were under no obligation, no legal obligation to continue to have these conversations if they didn't feel they were fruitful or going in a direction that Clemson wanted, or if Clemson felt they were dragging out for reasons unsatisfactory to the university. So they stopped communicating. They get a new lead counsel, stop communicating, and within 2 weeks of that, they filed a lawsuit down in Pickens County, South Carolina. And then 2 days after that, the ACC files the countersuit in Charlotte. So there was some open dialogue about a wide range of topics that wound up going nowhere once Clemson went silent.
Tony Siracusa, last word on college football, the ACC versus Clemson and Florida State in court on 4 different fronts. Again, it's both of those entities, meaning Clemson and or Florida State, with the lawsuit against the ACC and vice versa in 3 different states. So based on where we stand right now, what are the key dates and or situations that we either know about or you can anticipate based on your expertise and following of this situation?
Sure. Important to note that the school lawsuits in their home states are about getting out of the grant of rights and getting out of and still owning their TV rights, which the grant of rights says you don't. Once you leave, we still own them. The schools are saying, once we leave, we're not a member of the conference. We own them. This only applies to members. We're looking to not be a member anymore. So you're looking at interpretation of the contracts. That is what's going to happen at trial. We're a long way away from trial. We're still getting appeals on first hearing motions and things like that. We're a good year away from any trial whatsoever. So here's where we are next, because the ACC lawsuits are about breach of contract. You're looking to get out. It's a breach of contract. We're suing you for that. It's not even really about keeping the schools in. It's about you're breaching the contract, and there's got to be a penalty for that. So here's what's next. Florida State, as we mentioned, has filed an appeal with the North Carolina State Supreme Court. We are probably 9 months away from even getting a shot at that. Clemson has 30 days to notify the Mecklenburg County Court whether it intends to appeal. So 30 days, you're looking at mid-August before they have to make a decision whether they will appeal. I don't anticipate it will take that long. I think they will do it well before then. I think that they knew the decision that was coming. Most of us did, based on the previous Florida State decision. So they probably already have their paperwork ready to go. We have what's next in South Carolina is a hearing, the first hearing in Judge Gravely's court, Perry Gravely, about the ACC's motion to dismiss Clemson's lawsuit. and that's next on the docket. With regards to Florida State, in Leon County, Florida, the judge down there took 3 hearings before, and 2.5, almost 3 months before he finally wrote his ruling to deny the ACC its motion to dismiss. The ACC has already filed or will be filing an appeal with the appellate courts in Florida. That will be heard probably sometime in the next 90 to 120 days, so sometime this fall. So the next real, I guess, activity, if you want to put it that way, is going to be in Pickens County, South Carolina, where there will be actual hearings on some motions from the ACC.
So, Tony, I'm going to throw this one at you because this is what's on the minds of everyone who cares about this.
Sure.
And I don't know what your level of confidence in this answer will be, but what is the anticipated outcome?
There was a time, and I'm pretty sure you and I talked about it, probably even on your show, that I was of the mind that the ACC had to have a judicial verdict in order to maintain its cohesion and keep everybody else in. I'm no longer of that mindset because these cases are going to drag on. I think that there can be a settlement, an out-of-court settlement with the schools, but it is going to be expensive. I would put that number, and I've talked to people on following the lawyers, and that number is going to be north of $350 to $400 million to buy your way out of it. That's on top of the exit fee, which is already established at $140 million. Because the exit fee, as it's in the bylaws, is 3 times what the current operating budget of the conference is. So it's kind of a moving target over the years. Right now, that would sit at about $140 million. Both schools are ready to pay that. That's fine, but they got to leave with their broadcast ownership in their back pocket, or they really hold no value to another conference. That having been said, I would look at $350 to $400 million to get that done. Florida State can do it. Florida State is taking on private equity money now. They've reached a new deal with a new marketing company that they've worked with in the past that it takes care of all sorts of things like hospitality at the stadium and premium seating and the renovation that's going to be going on at Doak Campbell. And that's worth about $200 million to the university. So they can do it. I don't know that Clemson can, but really the point of the number is to scare off anybody else who wants to try this, because there are all the rumors about University of North Carolina, Virginia. They're both AAU academic schools, so would be viable for the Big Ten. It's to scare off the rest. Can you still have the ACC without Clemson and Florida? It's clearly not as attractive from a football standpoint to ESPN. And there would probably be a reconsideration of the contract. Remember, the schools are locked in through the grant of rights through 2036. Turns out ESPN isn't. Turns out there are 2 thresholds where ESPN has an opt-out that they can say, you know what, we're done. And then the ACC doesn't have a TV contract after that. And that's part of the grievance from the universities. You locked us in, but didn't tell us about ESPN's opt-outs. Now, either shame on the ACC or shame on your attorneys for not finding that out and doing your due diligence. Take your pick. It's probably some of both. But I think that there can be a settlement, but it is going to be probably the biggest sports out-of-court settlement between a conference and universities in the history of the setup as we currently know it, because you have to scare off the rest from leaving.
And just to clarify, Tony, that 350 to 400 million, well, it's an estimate, but it's also a projection of sorts.
Sure.
that is reduced each football season by whatever the media rights of the home
Yes.
games of that particular school would then have been cashed in by the ACC. Therefore, it would come off that total.
Yeah, you're absolutely correct. If this negotiation or this settlement, if you will, if that comes up sooner rather than later, yeah, it's 350 to 400 million. If it comes up in 2028 or 2027, we're now talking about a smaller number of years that's left on the grant of rights contract. So that buyout number is going to shrink. Absolutely.
And if you do the math, the rough math, if the contract is worth roughly $40 million per team, if the courts don't view Florida State and Clemson as being anything other than the average ACC school that's part of this equal distribution, then it's about a $40 million per year. And if it's only the home games, maybe it's 20 or 25 million. And if you do the math times 12, that's about where we come to that $400 million range.
It is. And you're looking at the ACC basically demanding a premium for the disruption of the conference. There will be, who's going to cover whose legal fees. And because I got news for you, these are expensive lawyers that both sides have. These aren't the guys advertising on TV that will work on a contingency basis or, charge $100 an hour. One of the ACC attorneys in the Florida State case in Charlotte actually used to be a member of the Florida State Supreme Court. These guys are expensive and they are on the clock for a lot. So it's, there's going to be a lot of the particulars in there. And the dollar figures are going to fluctuate and they'll move around. But really, if you think about it, this is a true sign about how football drives everything. Because, North Carolina, the state of North Carolina, heck, the ACC to a large degree is a basketball conference. And, you walk around the state of North Carolina, whether it's in Raleigh or Durham, and the talk, sure, they talk football and they like their football. And NC State has a rabid fan base for football, but it's still a basketball state. And so to have all of these court cases in North Carolina, in Charlotte, about the value of the football program and the university and ESPN and the relationship there, and have it really be all about football is really quite eye-opening. ESPN has had lawyers in all of the courtrooms to this point because they want to protect the secrecy of its contract with the ACC. And so, for instance, in the Florida State case, both in Charlotte and in Leon County, the ACC, when it submitted the contract with ESPN as part of the discovery, it's about 165, 170 page contract. Pages 100 through 130 were left blank when they turned it in because ESPN's contention was we can't give away our secrets as to how we negotiate. We can't have it out in public in a public court hearing and have Fox and NBC and CBS be able to see the nuts and bolts of how we were doing all of this. Clemson, strangely enough, in the matter in South Carolina, came to a pretty quick agreement with ESPN and with the ACC that they would agree that everything be redacted, that need be redacted, and that the entire file be sealed with the contract so that it would never get out in public. It would never be, for instance, I can go on and pull the dockets on this case. And you can use Pacer and, you can use different things that lawyers have access to and pull these things. And I've got all that, but you can't pull the ESPN contract. It's sealed. They reached that agreement pretty quickly. Florida State just now came to that agreement with, that Florida State lawsuit is 2 months older than the Clemson lawsuit. And we're just now at the point this week where the two sides came to an agreement to have everything sealed and redacted so that it could be put into the discovery for the case.
Well, we will continue to wait and follow along, and many will continue to be fascinated. Tony Siragusa, last word on college football. So we certainly encourage everyone to check out Tony's work and the rest of the staff there at Last Word. Thank you so much, Tony, for stopping by.
All right, Mark, always glad to do it. Be well.